My name is Bill Jones with recapturefederalism.com and also operationofficialmisconduct.com. I'd like to talk today about the Constitution, one of my favorite subjects, and Article VI. It's not one that you hear too much. Of course, the Constitution of the United States is very, very important, the whole Constitution. But Article VI is very special for a couple of reasons. And it starts out, we'll go through this, we'll dissect it. The first paragraph, there's three clauses. And the first clause is relates back to the Articles of Confederation, which the Constitution was in effect replacing. The Constitution is a federal system, but an agreement between the governed and the governing. It replaced the Articles of Confederation, which was set up after the victory of the American Revolution. Went for about 10 years. And when the United States operated, they had debts and engagements for those 10 years. And in this clause, they're accepting that those engagements and debts were contracted and that they would be good on them. So it's all debts contracted, engagements entered into before the adoption of this Constitution shall be valid against the United States, which is the people, under this Constitution as under the Confederation. The United States with the Constitution continues to be a confederation made up of 50 constitutional republics and one federal constitution, and that's where the Constitution, Article VI, comes in at, replacing the Articles of Confederation. Then we have Clause 2, which is the Supremacy Clause, having to do with laws and treaties. And I'm going to go through, and then some of these words I'm going to stop, and I'm going to have a sidebar and give it a definition so we truly understand what they're saying and what they meant back in 1787, 1788. The Constitution and the laws of the United States which shall be made in pursuance thereof. And we'll go into a sidebar for pursuance. Pursuance, the act of pursuing, especially a carrying out or into effect. Relating to the Constitution, you carry out the Constitution, it was a continuation. Had the Constitution, then to make it effective, you pass laws, have treaties. It is implied that when you do that, to put it into effect, that those laws and treaties should be in accordance and not contrary to the Constitution of the United States. After pursuance, we continue on. And all treaties made, or which shall be made, under the authority of the United States. And we'll go to a sidebar on authority. We have definition of authority. This one is 1B, is relative to the Constitution. And also, it comes from, the authority comes from the Declaration of Independence. But 1B, conclusive statement or set of statements as an official decision of a court, a decision taken as a precedent. And the Declaration of Independence would qualify under that definition. And here we have the reference I made concerning authority and in the Declaration of Independence. the last paragraph. And the authority comes from we the people, going back to day one. And in that last paragraph, the authority comes from, and quote, and by authority of the good people of these colonies, solemnly publish and declare that these united colonies are and of right ought to be free and independent states. There's your confederation. That would lead ultimately to a compound republic. At that time, the 13 colonies during the Revolutionary War, they came up with state constitutions. But you notice it's the authority of the good people. Why do they say good people? Because everybody wasn't a good person for the Revolution. There were patriots for the Revolution, and then there were people who still wanted to be under the hand and fist of the tyrant King George. It was a group called Tories. So this was the patriots. They had the authority, and we still have millions and millions of patriots in this country, friends of the Constitution. And we have some people who are not friends of the Constitution. They're enemies of it. Many of them are public officials. Shall be the supreme law of the land, and the judges in every state shall be bound thereby. And we're going to go to a sidebar with bound. Bound is used twice in the Article VI. It's a legal term. One, placed under legal or moral restraint or obligation. You're obligated. You're duty bound. It's used twice. Very important. Here's the tie-in with morality and the Constitution. Anything in the Constitution or laws of any state to the contrary notwithstanding. And we'll go to a sidebar with contrary. Contrary. A fact or condition incompatible with one another, opposite. One of a pair of opposites. Now, in the Constitution, between the state constitutions and the federal constitutions, there aren't any opposites, especially with the Bill of Rights, the basic human rights. They're the same, federal level and state level. The state level and state constitutions are there to be a backup when we have people, enemies of the Constitution, committing wrongful action, evil things, evil doings, wrongdoings against the people, oppression, and then you still have the states to back you up. And at least that's what originally was supposed to be decided and should be decided still today. This next clause, the last paragraph here, is the religious test clause under the Constitution of the United States, Article VI. The senators and representatives before mentioned, and the members of several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation. We've already had a sidebar on bound, and here is bound again. And we're also going to have a sidebar on oath or affirmation. Now we have a definition of oath. Very important. And you'll see a tie-in oath with religion and morality. A solemn, usually formal, calling upon God or a God to witness the truth of what one says or to witness that one sincerely intends to do what one says, solemn attestation of the truth of one's words. Now, you see that in Article VI, in the supreme law of the land, and authority, and being bound legally and morally. This is important stuff, and this is what's really being violated in Article VI. And if you take a false oath, I would ask you, are you a friend or an enemy of the Constitution? Affirmation, definitions here. The act of affirming, something affirmed, a positive assertion, and the important one, relationship to the Constitution. 2. A solemn declaration made under the penalties of perjury by a person who conscientiously declines taking an oath. So the founders had consideration and respect for everyone, whether they were religious, non-religious, atheist. There's either an oath or an affirmation. To support this Constitution, that relates back to the oath and affirmation and being bound, a legal term, but no religious test shall ever be required as a qualification to any office. We're going to then have a sidebar on religious test, religions. Religious definition statements we have here of or relating to religion, believing in a god or group of gods and following the rules of a religion, relating to or manifesting faithful devotion to an acknowledged ultimate reality or deity, of relating to or devoted to religious beliefs or observances, conscientiously faithful. And that includes a whole group of different religions. And the founders were very open. They didn't single out any particular religion. And they welcomed all. They respected all. And that's what the Constitution does. But we have some people in the 20th century come along and say, well, wait a minute, them Christians, they can't be part of the state. There's a reason for that too, by the way, and I'll be doing a podcast on that stuff later on, because I often say the Bible is a lot of things to a lot of people, and to me, I look at it and I see political science from cover to cover. Definition of religion, and I'll also have one for the religious. There's several of them. The one B2, commitment or devotion to religious faith or observance, and that would be your traditional standard religions. And then there's some others which aren't standard traditional. Then in 4, a cause, principle, or system of beliefs held to with ardor and faith. And those could be non-religions. Atheism, for instance, and political system, Marxism, communism. So when you talk about religious test, you get involved with religions and non-religions and political things. Here we have a definition of church, and there's several of them, and they can all apply to this terminology, separation of church and state, and religious test. You notice in the Constitution, Article VI, it's a religious test. It's not to any specific religion. It's religions in general. And what do we have when we say separation of church and state? We're singling out Christians, the majority religion in the United States, 220 million Christians. We're singling them out and in effect telling them they are not to participate officially with the state, that they're supposed to be separate from the state. That's placing a religious test on Christians. It's anti-Christian. But no religious test shall ever be required as a qualification to any office or public trust. We've talked about religions and religious tests. Now let's talk about public office, public trust, and what that means. What does public trust mean? How is it violated? How is it breached? And what about public trust? Wikipedia has a little blurb on here about public trust. Let's see what they say about it. The concept of public trust relates back to the origins of democratic government and its seminal idea that within the public lies the true power and future of a society. Therefore, whatever trust the public places in its officials must be respected. Must be respected. One of the reasons that bribery is regarded as a notorious evil is that it contributes to a culture of political corruption in which the public trust is eroded. Other issues related to political corruption or betrayal of public trust are lobbying, special interest groups, and the public cartel. And all of those things are prevalent today. Political corruption, lobbying, special interest groups, and public cartel. The biggest, most powerful special interest are the two political parties, and especially the Democrat Party. And I'll say it again, they have no legal basis, no authority. And we talked about authority. They have no authority from the people to govern and governing. Look at Article VI. Look at the Declaration of Independence, the Constitution, the Articles of Confederation, and especially in Article VI and the Supremacy Clause, and also the Religious Test Clause. There is no mention of political parties in any of those documents. That was intentional by the founders. We have in this article here an example of betrayal of public trust in past history. The assassination of Julius Caesar. He was killed by Roman senators who believed they had to act drastically to preserve the republic. He wanted to be a king. They weren't going to have any of that. And one is a breach of trust. There's a couple, specifically where you have trustees, law, a violation of duty by a trustee, and also public officials is other one, and others. A violation of duty or responsibility. Part of the public trust. The opposite of having the public trust is public corruption. And what is public corruption? From the Legal Information Institute, they have it down here as public corruption involves a breach of public trust and or abuse of position by federal, state, or local officials and their private sector accomplices By broad definition, a government official, whether elected, appointed, or hired, may violate federal law when he or she asks, demands, solicits, accepts, or agrees to receive anything of value in return for being influenced in the performance of their official duties. Wow, there are a whole lot of things that involves. My site, Operation Official Misconduct. And that's what my site is all about. And what is official misconduct? It's improper and or illegal acts by public officials which violate his or her duty to follow the law and act on behalf of the public good. Often such conduct is under the guise or color of official authority. Yep, that's what it is in Article VI. People either follow the Constitution or they don't. And then when they don't, they say they are. The devil spends a lot of time trying to convince people he's not the devil, not evil. You notice on the bottom of this slide, I'm not going to get in too deep. I'm going to have probably several podcasts regarding the official misconduct and the different forms of official misconduct. As you can see, there's many, many, many.